have a look at phase 2. This is what is going to happen on the 1st of May.
Next slide,
That's
thanks.
it. So first of all, rent repayment orders. Why am I putting this up? Because this comes in with the local authority. It comes in with no win, no fee. And it really does, as I say here, it complements the local authority enforcement. It was 12 months, it's now 24. So if you're looking at the average rental here, from a potential fine, you're looking at around about £28,000. But really a case of sort of like rent repayment orders. Also, it is a case of how much rent that you would pay back to your tenant, resident. So this is really a biggie. But again, it's a biggie for the people that don't follow the law. We've got misusing a possession ground. Now, be careful, because possession grounds are changing. So the fact that if you don't know what ground to use come May the 1st, you need to get advice. Please just don't download something from ChatGPT, because it's not going to be correct, I promise you. ChatGPT is actually still talking about the Renters Reform Bill, which was really quite old. Breach or enforcement action, false information. If you're giving false information about the property, harassment. You saved someone this week, didn't you, on the harassment side of things?
Yes, I did. Sorry, just so you don't hear me breathing. Yes, I did. I had a interesting health check this week from a lovely landlord, bless him, and he's had tenants in there for some time. Their relationship was great, but there was some issues with rental, and as you can imagine, understandably, emotions did start to creep in, and the landlord's messages, let's just say, when I saw them become more frequent, more reactive, and let's say the tone started to change. And when I actually reviewed it properly, while it wasn't intentional, it was borderline harassment. So I identified the risk, and let's just say we had some words to say we need to be very careful what you're sending, and actually come through, us. We're the ones that need to be having that communication, because situations can escalate and it can become a problem further down the line. So yes, I stepped in and let's just say took over the communication. So we stopped it becoming an issue.
Okay. And then on the illegal eviction, I'm sure everyone here understands that you can't just basically go and change the keys. But again, we have spoken to people where they get angry about it. Emotion kicks in. It's my house. I want it back. I'm going to change the keys. That's illegal eviction. You are now looking at a very big fine for actually doing that. And also with regard to licensing, you've got selective licensing in Peterborough. We've been talking to the local authorities to find out what licensing they are coming in. So we're going to be keeping ahead of the game there. But we do know where the streets are in Peterborough. At the moment, that's where that's as far as we are finding out, I suppose. So can I have the next one, please? So, abolishment of Section 21 notice. This seems to have caused the biggest, oh my God, I can never get rid of my tenant. Of course you can. The thing is, why would you want to? I think you've got some figures on that.
I was going to say,
you?
can I interrupt here, because I think this has been huge. It's like I could never get my tenant out. They're going to be in there forever, and it's going to be awful. But actually, our figures, when we looked at the last 12 months, 82% of tenancies were ended by the tenant, and actually only 11% of them were via a Section 21, and that was genuinely because the landlord was either moving back in or they wanted to sell the property. None of them went to court. Everything was smooth. So if you have a good tenant and you're getting a good rate back on your property, why would you want to evict them?
So anyway, it's going. And why is it going? Because the belief is that residents don't complain about the types of properties that they're living in because they would be given a Section 21 notice. It got called a no fault notice. Well, everybody basically, there is a reason for it. So if you have a Section 21 notice running, you have until the 1st of August of this year to action any Section 8. It is prior to the 1st of May, and you can serve a Section 21 up until midnight of the 30th of April. I wouldn't suggest you do it then, purely because you've got to prove what you've done. But again, I've said it's subject to the service provisions in the tenancy agreement. So if your tenancy agreement says you've got to allow 3 days, it's got to be working days, how it's going to be served, that's when it comes down very much to the tenancy agreement itself.
That's what I was going to say there is, when we do Section 21s, we do allow just over 7 days to have that process, because, it has to go, we have to prove postage, the tenants have to receive it before then them 2 months start. So yeah, if anybody is looking to serve notice, definitely don't do it on the 30th of April. Let's plan maybe a couple of weeks before that. Sorry, Max.
No, that's fine. And Nick, I think it's sort of like basically in London, getting tenants out is subject to an 18-month delay. What we have found, where we've served a Section 21, 99% of people move on. They know the road that they're going down. They tend to move on. If you are, I'm going to say one of the unlucky ones, because we manage quite a few tenancies, and where we found that people stay on, yes, there is particular reason, but I suppose in some respects, and I know we've picked this up before, make sure that you've got legal protection insurance. If it's going to happen, it will happen. Make sure you are covered for the risk. But it really is a case of from that point of view, yes, we don't know the time frame. Yes, that is very much a case that it's taking long. From our point of view, what we're seeing in the local courts is we're not having those delays. However, as I say, it's 99% of people move out at the time when they're asked to move out. So
we've also had, I think, Joanne's answered Mark's question, but I'm an executor to my late father's estate. He has a couple of occupied rentals. Obviously, probate will take many more months. Will executors have to register at present? I don't know if I can retain the properties long term. I think actually something that may be of interest to you, Mark, going forward very shortly, is something that we're going to offer in this webinar. So hold tight, because we may be able to help there further.
Yeah, that's a very good point. Okay, let's go on to periodic tenancies, fixed term tenancies, assured tenancies. So there's various names that you will hear. A periodic tenancy, really, an AST, an assured short hold tenancy, has a fixed term. Once that fixed term comes to an end, contractually it will go on to a periodic tenancy. That is now disappearing. As at the 1st of May, all tenancies will revert, as I've said, to an assured periodic tenancy. And just to really give you an idea, again, the landlord will have until the end of May to serve the relevant notice. That is the written statement advising tenants of their rights under the Act. Failure to do so will be considered an offence of £7,000 for a minimum of £4,000. Now again, we're getting a little bit of, I suppose in some respects, difficult information where people are saying you don't have to actually serve anything. This is why we are going to be serving notice. We will have 30 days to actually serve everything. So we will actually change. We will be sending this out to protect the landlords we work with. And all right, the government will release the relevant documentation by January. They have started, so tick on that. And I can see some things. What is the recourse of the Light of the Renters' Right Bill if one has an only tenant who may prefer being difficult to common sense? Law will apply, to be perfectly honest. And again, if you do have a difficult tenant, maybe you need, let's have a chat and let's see how we can help to do that. Dominic, will agents do this automatically on our behalf? I think you're saying, will we be sending out the details? I think I have said yes. Does that answer your question? If you could just tell me there. So
obviously, sorry to add that, Max. Yeah, if you're obviously a managed owner with us, we will. If you are with another agency, we obviously can't comment because we don't know what your agent is going to do. We would like to assume that they would send it on your behalf, but let's just say the calls I've had recently when I've been checking compliance are rather concerning. So I would check that obviously with your agent, but actually, if anything, please come to us and we would be delighted to help as well. Sorry, I'm butting in again.
No, you carry on. We know what we know. One thing I would say here, this has all happened in Wales around about, I think it's 3 years ago, Rent Smart Wales. It did not change behaviour at all in the private rental sector. So we're working on the basis, Section 21 went in Scotland, I think about 7 years ago. It didn't change behaviour. In fact, the rental market became stronger. Purely people, I suppose in some respects, they felt once the dust had settled, they felt more secure. So lots of people, I say countries, have actually gone before us. We are following the path of Scotland and of Wales. So we have seen what's going on. Everything indicates nothing changed, apart from a lot of compliance, obviously.
It was, if anybody's been on the webinars for some time, I did actually show a graph. It was, probably it may have been even last year now when we were talking about it, and it was 8 years. It was 2017 that went Section 21, and the graph, if anybody remembers, there was a real worry where it dipped, and then suddenly it was,
it just went up.
It was 2019. It did take us a year or so, and then it just shot, and it's been great ever since. So
okay,
sorry, I'm
so CJ, no, how do private landlords get this information? CJ, if you're asking that question, you need help, because if you I'm so sorry to be so direct, but there isn't a case of I can Google it. You need to understand what is going on and what you need to do. So very happy to talk to you, but it's not a case of pressing a button and just finding out. And Mike, I self-manage my properties with a long-term tenant you placed for me. Will you prefer notices for those such like me? Again, we would do that for our managed landlords at the moment. What we've got to do as a company is really go through what we will be doing with those where we have set up, let's say, a let-only tenancy, because what we don't know is what has happened in between us setting it up and picking it up now. And I think you've got a little story about that, haven't you?
Funnily enough, I have. Yes, I have. I had another conversation, actually, again, it was yesterday, with a lovely self-managing landlord that we put tenants in for, it was about 5 or 6 years ago. The owners now want to move back into the property, so they need to give notice to their tenants. They'd never done it before. This was just a Section 21, never done it, so they just wanted my advice as to what they need to do. So there I was, just going through the detail of just checking to make sure, because again, we haven't been involved, if they've been doing things correctly over the course of the tenancy. And within 5 minutes of the call, I realised they hadn't been serving the correct documentation throughout the tenancy, hadn't been served consistently. So they wouldn't have been able to give notice. It would have been invalid. There was a couple of reasons. I'm not going to go into detail why, but we had the How to Rent guide that changed in 2023. They hadn't served that to their tenants. They hadn't been serving the gas safety certificate every year to the tenants. So let's just say they had quite a lot of backtracking to do, first of all, to get them in a position where they could actually serve it. So it's really important to make sure it's not now, it's even actually, what's happened in the past. You just need to make sure that you're doing everything correctly. And I think from what Mike said, we can help you prepare notices and things, but we need to make sure what you've done throughout the tenancy as well is compliant to make sure you're in the right position.
Mike, it might be an idea if you do actually just sort of put down some time to talk with us, because we'll know how the tenancy was set up originally, and then we can talk that through with you if that helps. Can we carry on to phase 2? So section 8, this is going to be the new way of giving notice. Now section 8 used to be made up of 17 grounds, and it was a mixture of mandatory and discretionary. What do I mean? If you end up in court, a mandatory ground, as long as you have supplied all the right information, done all the right things, everything like that, the judge must give you possession. Discretionary, that's down to the judge on the day. You never go to court on a discretionary ground. Absolutely never, ever, ever. So section 8, you now, from 17, there are now going to be 26 mandatory grounds, and a couple of those mandatory grounds is if you want to sell the property, if you want a family member to move in, if minister of religion, from that, an agricultural tenancy. So there's a variety of things that come within. They've really extended the mandatory grounds. The discretionary grounds, there's 11 discretionary grounds. So we've effectively gone from 17 overall grounds to 37. They've extended quite a bit. And I was a little bit sad, actually, that under discretionary grounds, they'd actually included antisocial behaviour and domestic abuse, because it's one of the things, domestic abuse is one of the things as an agent we do have to deal with. And it's not easy. It's not, and basically, even if we've got all of the facts, how we deal with it is very, very difficult for the landlord. And antisocial behaviour is exactly the same. And the law said, and if you go onto the government website, you can get a whole list of the actual notice period. So antisocial behaviour, you only have to give 2 weeks notice. Fabulous. But you basically, it's a discretionary ground. So would you go to court on that? No, even though it's 2 weeks. So again, there is quite a bit of detail within here, and we're not going to go into the full detail on section 8. If anyone is interested, I would definitely go onto the government website, renters' rights, and they've got a really good section there on what notice that you have to give. So notice periods have been increased, both for the landlord and the resident. The resident will have to give 2 months notice, whereas they only have to give a month now. And the landlord has to give 4 months notice, whereas they have to give 2 months now. Now, one of the big things within section 8 was if you had rent arrears, and you wanted to basically go to court over rent arrears, or that would be the best way forward. Obviously, in the past, you would issue a section 21 and section 8 grounds. Now you will only have section 8 grounds to basically issue, and ground 8 is issued at 2 months. At the moment is issued at 2 months of rent arrears. It will be 3 months of rent arrears. So again, what do you need to do? Because this sounds awful. So first of all, what's the reality out there? Reality is 99.3% of our landlords were paid on time. The outstanding is really people, to be perfectly honest, that actually had forgotten to increase their standing order when we've had a rent increase. We do actually have one big one going through at the moment, so that is something that we are taking through the courts. But it really comes down to choosing the right resident in the first place. And again, I'm going to come back to you on these health checks, because I think you found someone who, lovely person. It was it the friend of the father or something like that, where they got, oh no, they're really lovely. Then they all fell out.
Yeah.
And
Yeah, and this, yeah, I love health checks. It's actually at the moment I'm finding, like I say, there's little gaps in things where they could become major. But yeah, we had somebody, it was a friend, they didn't do any of the referencing very recently. There's again things that have changed. We had May of this year, sanction checks had come in, so hadn't done any right to rent checks on their tenants, hadn't done a sanction check on their tenants, and it's like, okay, these issues here are going to become big issues then when you want to serve notice in the future. So it's really, really important, again with tenants, as well as Max said, making sure even if they are your friend, your sibling, your sister, we have it a lot, things can go wrong. So it's just making sure that you have everything in place that you need to have correctly. And as Max said before, what needs to happen, pre-qualification, as Max said, making sure that you have the right tenant. When we go through referencing for tenants, it isn't just we're dotting the I's, we're crossing the T's. We're checking on Facebook, we're checking Google just to make sure what's going on there. We're also checking bank statements, okay, are they overdrawn every month? All of these things can make a huge difference when we're choosing a tenant going forward, to make sure that they're right and they can afford the property. And one more point, sorry Max, I am going to make on this as well, that you've stressed before on a couple of slides, is please make sure, if you haven't already, that you've got rent legal protection insurance on your property, because yes, it isn't ideal if tenants are in arrears. And again, we don't really see it in what we do, because we make sure we pre-qualify, and we have good relationships with our tenants as well. If there's an issue, they will normally come to us before it becomes a problem, because what we want to do is we want to work out a solution before it does go to court. So we come to an agreement before it gets that far. But yes, main thing I would say here is, please make sure you have rent legal protection insurance on the property, because it will take away a lot of your worries. And for the cost of cup of coffee a week, or cup of coffee twice a week, to me it's priceless, should we say. Oh, we've got a few questions in here. Shall do you want me to read them out?
Sure, go.
So we have got, what protection does the landlord have if the tenant simply stops paying or paying less?
Okay, you're obviously very worried, and I can understand. I'm a landlord, I am an investor, I run a business for rental, we look at data. The thing is, why would someone stop paying their rent? Did we all stop paying our mortgage when the rates went up? No, because we would have lost our home. The thing is, a resident they're living in their home, they want to pay that. The protection, if you are worried about it, is the fact that you need to get, I think we've said it 3 times now, but it's rental guarantee, rental protection. That is really the best protection that you can have if you are that concerned. And could the change in legislation result in more tenants defaulting on rents, in the knowledge that the law is in their favour? The law is in their favour at the moment. It's a 2 months difference. So again, I can't see that the law is the law as it is at the moment. It's the way you handle it. If your immediate reaction is to go to court, that may not be the right way. Steph's mentioned when we had COVID, first thing we did on that, when we all got left at home, was to ring up every tenant. How are you doing? How are you going to pay the rent? Nicely wrapped up. And we got payment plans in order. So it was a case, there's always something that can be done. And Nick,
I know this is a story.
Oh God!
So Nick, a friend, had a resident in his HMO threaten other tenants in a balaclava. Yikes! Oh, and shot a Tesco delivery driver with a BBC gun. Wow. He served a Section 21 notice for unacceptable antisocial behaviour. I guess under Section 8 they'd need evidence of antisocial behaviour. That could get awkward for tenants still living with the antisocial house sharer whilst you go through the motions and have to get evidence from other tenants. Involved police.
Well, I think involved police, I'll be looking at with the BBC gun, is that would be my default there. But again, I know I keep on talking about it, it's negotiation. There's this, to me, the landlord and tenant is a mutually beneficial relationship. The landlord takes the risk on the property, and the tenant has no long-term right to that property, but there is something mutual beneficial because someone is living in a home that someone is providing. There are always going to be very difficult people. We run over 800 tenancies. We do not have an issue with one of them, anything like that at all. We've been in business for 20 years. We've had more, I suppose in some respects, I would say queries, where we need to help is with mental illness. If people have had mental breakdowns or anything like that. It is very rare that you get into that, and I appreciate it's your friend Nick. He is very unlucky, is all I can say.
We have Lydia. What is a sanction check? Okay, it's good we manage your properties, Lydia. A sanction check is basically, it was introduced on the 14th of May, and it's a process of screening individuals, its companies, against basically an official sanction list that the government have now produced. If we find somebody on that sanction list, we have to go through channels to report them. That is what a sanction check is.
Okay, and before we leave Section 8, there is again one of these monkeys out there. In Section 8 there's a Ground 6, and Ground 6 is around development or redevelopment. And the monkeys out there say, oh, you can use redevelopment, just put in a new bathroom. I promise you, redevelopment means you have an architect, you've had a surveyor, you've got reports, you are going to redevelop the property. You are not going to repaint it, you will not get away with it, and also you will not get away with just saying I'm putting in a new bathroom or kitchen. So again, just be aware of what the monkeys are giving you advice on. Use redevelopment at it and pretend you're putting in a new bathroom. You will not get it through the courts if your tenant basically disagrees with you. Let's go on to the next one. So, rent reviews. Now, if you remember that little graph, or it wasn't a graph, I'm using your words there. It was table. Thank
graph,
you.
Yeah.
A table.
No, graph, actually, it's not. It's a table. It wasn't. Yeah, it's a little table.
A table. So we have a table of what is actually being achieved out there. That table is made up of the properties that we manage. It is made up of the rent reviews that we put forward, and obviously remarketing. We do not split out the two. Now, there are new rules around rent reviews, but I think from our point of view, it's very difficult for me to talk about new rules because we've been doing this for 2 years. First of all, you can only review the rent once a year. Anecdotally, there have been landlords in London who, every 3 months have put the rent up £500. I've never come across that. I've come across some landlords who have basically not agreed with our advice as to what the rent should be, and we are agent for the landlord, so we have to work for the landlord, so we've put that, and tenants have given notice. But it really is a case we do understand what is going on out there, and instead of 1 month's notice, you need to give 2 months notice. Again, difficult for me because we've been doing this for the last 2 years, where we review rents effectively 3 months before they are actually due, so that we can hit the 2-month stage. Now, out of that, you need to have evidence-based results, and that doesn't mean clicking on Rightmove and going, in East Anglia the rent is this. You will need to have, like we have, we can prove the last property that rented out in that area, the square footage, the condition, because we're looking at everything, matched with really what is going on with the rent in the actual market. So there's a lot that needs to go into that rent review. Now, Anecdotally, we're being told that residents will be encouraged to dispute it because we have to issue a Section 13. Well, I think the answer there is, if it is a case that residents are encouraged to dispute rent, then you talk to them before you issue the Section 13. So you find out what the outcome may be. It is a negotiation. Nobody likes to hear that the rent is going up. I didn't like to hear that my mortgage was going up. I don't like to hear that my car payments are going up, but I go along with it. But effectively, it is a case, I think, again, a lot of fear mongering out there is that tenants are encouraged to dispute. If you're coming with fact-based evidence and you've spoken about it, and people can see that actually if they leave they're going to have to pay more or whatever, you've got a really strong point. Now, what's the FFT? It's the First Tier Tribunal. It's in place now. So again, this is already the law. Tenants can go to the First Tier Tribunal now. Always been the case. And on a Section 13, always been the case. The difference is that reviews won't be backdated. So at the moment, if a tenant goes to the First Tier Tribunal, the date of the rent increase would start when we actually applied for it. Now it will be when the First Tier Tribunal agrees. Again, what's reality for us? 20 years in business, we've had 2 that have gone to the First Tier Rental Tribunal. And I suppose you could say, you said you've never dealt with difficult tenants. Yeah, these were quite difficult, but we negotiated, we got there, and we won. So it's really a case of there are new rent reviews out there. And I suppose in some respects that's going to lead very much on to what we would like to offer you, because as I said, I was quite rude there, CJ, and said you need help if you're asking that question. We would like to give an offer, and that offer is a health check, and if we could get the offer up, that would be fabulous. Don't know, is it? So what is this all about?